Hearing in the appeal, Elgizouli, Secretary of State for the Home Department.
My lady, I appear for the appellant in this matter together with my learned friend Mr. Richard Hermer, Queen's Counsel, Joe Middleton, Ed Craven and Hugo Morrison. The respondent is represented by my learned friend Sir James Eadie of Queen's Counsel, Hugo Keefe of Queen's Counsel, Victoria Wakefield, Queen's Counsel, Claire Dobbin and Matthew Hill. The intervener reprieve is represented by my learned friend Mr. Mark Summers, Queen's Counsel, and Jacob Bindman. And the Information Commissioner intervening is represented by my learned friend Jerry Ficena, QC, and Conor McCarthy. My lady, there are some additional documents, and in addition to the basic documents filed, I hope the court has received a reply filed about a fortnight ago, a short reply, and also a short note on the approach of the United Nations Human Rights Committee to the issue before this court. That's to say, the legality of providing evidential assistance, which may lead to the imposition of the death penalty abroad. My lady, there is that additional note. My lady, there's also an application to admit new evidence. Could I deal with that after making certain introductory remarks? I think it can be dealt with quite shortly. And my lady, there's also in place an order prohibiting publication of the appellant's address.
Yes.
Would the court confirm that?
Well, that order was of indefinite duration, and so it remains in force. So if anybody were inclined so to do, that would be a contempt of court.
My lady, just to indicate, I'm going to speak for an hour and 50 minutes, and then my learned friend Mr. Hermer is going to deal with the data protection point as we divided it below. My lady, can I just first say something about the context? The appellant, Mrs. Elgizouli, is solely concerned to protect her son from the death penalty. She, of course, recognises the enormity of the crimes alleged against her son, Shafi el-Sheikh, and against his alleged accomplice, Alexandra Coty. She recognises that they should face justice. She's expressly said so in her statement. But she submits that they should face justice in this country, the country of their past citizenship, the country of the two of their alleged victims, and the country which has obtained the main body of evidence against them. I think there's some 600 police statements. That is the subject of separate judicial proceedings, but the current reality is that they face the risk of trial in the United States, and if convicted in the United States, they face the real risk of the death penalty. A successful prosecution there depends on the evidence that this country holds. That's set out at 3.2 of the case. Our standard policy is not to provide such evidence in the absence of assurances that the death penalty will not be carried out. You have the reference in the Statement of Facts and Issues, and the statement there, the requirement of an assurance is consistent with all past practice when dealing with US MLA requests. But on the 22nd of June 2018, the then Home Secretary, Sajid Javid, offered to send the evidence to the United States without obtaining a death penalty assurance. Mrs. Elgizouli challenges the lawfulness and the rationality of that decision. In doing so, my lady, she's asking no more than that the Home Secretary should apply the settled policy of requiring death penalty assurances in all such cases. And behind that policy, there lies a long and honourable tradition on the part of this country of rejecting the death penalty as morally wrong in all circumstances. It was obviously that which led Parliament to abolish the death penalty more than 50 years ago in 1965 and to repeatedly reject attempts to reintroduce it. It was that which led to our signing of the two death penalty protocols to the European Convention in 1999 and then in 2004, by which we have now committed ourselves to abolish the death penalty in all circumstances, and that led also to our signing of the second optional protocol to the ICCPR in 1999 also. That can be found in volume 13, tab 139. But we've gone further than abolishing the death penalty in this country. Since the decision in Suring in 1989 and the signing of the sixth protocol to the European Convention in 1999, we have maintained a firm policy of refusing extradition or deportation to countries that impose the death penalty. And that's no matter how serious the offence and no matter how repellent the offender is alleged to be. That's not just some alien obligation imposed on us by the European Court. It's a voluntarily assumed obligation by virtue of signing the protocols, and we can be said to have adopted that principle as a legal principle of our own, just as it has been adopted in other common law jurisdictions, such as Canada in the Supreme Court case of Burns. Can I just give you the reference? It's paragraph 143 is the ratio there. And in South Africa, in the Constitutional Court's decision in Mohammed, which you have set out in the case at 6.4 at MS 284. And of course also, the European Court reflects that same principle in Al Sadoun, volume 1, tab 14, at paragraphs 143 to 144. Finally, going beyond the non-extradition principle, we have adopted a policy of not providing evidence that is likely to lead to the imposition of the death penalty without obtaining death penalty assurances. The existence of that policy was referred to by Home Office officials, by the UKSC and by Foreign Office officials in this case. My lady, again, if I can just give one short reference, it's at SFI 41, where it's described as consistent with all practice, all past practice when dealing with US MLA requests to require death penalty assurances. Moreover, the policy was publicly declared to the UN General Assembly on the 19th of April 2016, where our representative, Mr. Letwin, said, I quote, "The United Kingdom does not provide criminal justice or other assistance that may result in a death sentence being applied." And that's in the context of having linked it to our opposition to the death penalty as always wrong in all circumstances. You have the reference, it's quoted in the Death Penalty Project, but it's also at volume 14, page 7250. My lady, this policy of seeking assurances before providing evidence is repeatedly referred to as the logical consequence of this country's position of rejecting the death penalty as wrong in all circumstances everywhere. That connection is reflected in the statement to the United Nations on April the 19th, 2016, and it's referred to in the Foreign Office recommendation that's recorded in the UKCA briefing of the 18th of May 2018, where it says this, I quote, "To depart from the policy would undermine Her Majesty government's death penalty policy globally." We've given you the reference there. Moreover, the policy clearly accords with the obligation imposed on abolitionist states by the ICCPR as authoritatively interpreted by the Human Rights Committee in its General Comment 36, paragraph 63. And we say that the policy gives effect to a principle of law. Can I just try to formulate that principle? It is this, that in the exercise of its formal powers in the criminal justice field, the government of this country should not act in any way that is directly instrumental in the imposition of the death penalty. And that's drawing on my Lord Carr's words in Ismail explaining the underlying rationale of the extradition cases. It's directly instrumental, we say, in no less a way.
But in a way, I suppose you might argue that even if such a policy did not exist, it would have to guide the government. Even if the articulated policy did not find expression in government statements, it would have to be part of government practice.
My Lord, yes. And my Lord, the words of the ICC, the protocol, the first optional protocol, the two protocols that deal with the death penalty, the 6th protocol and the 13th protocol, in their first articles say no one shall be executed. and that's all they say. But that's been interpreted as meaning, nor shall we play a part in directly causing execution elsewhere.
Well, if you've got such a deeply entrenched, as you say it is, view in British society that the death penalty is anathema in all circumstances, a concomitant policy that you won't facilitate its imposition, it seems an inevitable, or as you say, a logical consequence.
My lord, we say so. It's the logical and indeed we say the legally necessary consequence. My lord, we've set out the reason, but that's the proposition. And my lord, we do say that it's important, obviously, that it's the exercise of formal powers in the criminal justice field. This is not just some provision of information in some informal exchange. What is being done is to exercise a criminal justice power, and that brings it within an area where we say the principle must apply, that we should never be directly instrumental in the imposition of the death penalty. My lord, just picking up on your lordship's point, in the Canadian case of Burns, the Canadian Supreme Court saw in the repeated rejection of the death penalty by Parliament an indication of Canadian society's rejection of the death penalty, and saw that as leading to what they called a fundamental principle of justice that led to non-extradition. And so, my lord, that we respectfully submit is of some assistance. The basis of our legal challenge is set out in our case at 2.2, but it's of course agreed that in authorising the transfer of evidence to the United States, the Home Secretary was exercising a prerogative power, but that power has to be exercised, we say, in accordance with the fundamental principles of the common law, the dictates of humanity, and the requirements of international human rights law. And we've developed that at 5.2 of the case. And we say that is particularly so where the power exercised was a formal power to provide assistance pursuant to a treaty in the field of criminal justice. It could not be a lawful or rational exercise of that power to facilitate the exposure of the appellant's son to the death penalty, and in particular, of course, the death penalty regime in the US federal system. As the court will know, my lady, the US death row phenomenon has been repeatedly condemned by the European Court, and indeed by our own Privy Council, saying that it is anathema to the common law to have these long periods of delay before execution. The average period of delay is 12 and a half years in the federal system, but even if one awaits, as Mr. Zagorski did, for 34 years before being executed, the US courts will not intervene. Even if one waits, as Justice Breyer points out, in the Gossip case, for 50 years, the US courts will not intervene. So that's the additional point. And we submit that because the death penalty offends against evolving requirements of humanity that are enshrined in the common law and in Article 10 of the Bill of Rights, 1689. Just pausing for a moment, we say that the Bill of Rights prohibits the infliction of cruel and unusual punishments. That has been described in the case of Boudram and Baptiste by Lord Slynn as a constitutional statute conferring rights. It's also been recognised by Lord Sumption in the HS2 case as a constitutional statute of particular power. And we say, if given a dynamic interpretation, and there's plenty of authority to support that, the prohibition on the infliction of cruel and unusual punishments would now extend to prohibiting the infliction of the death penalty. And if it's contrary to the Bill of Rights, how can the Home Secretary then facilitate the imposition of such a punishment abroad by being directly instrumental in its infliction? The court has our submissions on the death penalty regime. there's an almost inevitable risk that, that the suspects, if taken to the United States and if our evidence is provided, will be exposed to a prolonged period of waiting in anticipation of execution. 12 and a half years being the average, and you have the points about it could be far longer. And for that reason, too, we submit that it's unlawful for the British government to take steps that are likely to be directly instrumental in imposing them to such, in exposing them, to such a cruel and inhuman regime. My lady, the history of the decision in this case, very briefly, if I can go through it, the then Home Secretary, on the 22nd of June 2018, Sajid Javid privately authorised the provision of a substantial body of evidence collected by our police to the US authorities. That was under a mutual assistance treaty which permitted us to refuse assistance where such assistance was contrary to public policy or human rights. That's Article 3 of the treaty, which the court can find at Volume 13, tab 138. The Home Secretary did so. He provided that evidence knowing that this evidence was for use in a federal trial of the two suspects, and that if convicted at that trial, there was a real risk that they would face the death penalty. That's set out at paragraph 45 of the SFI, page 243. It was a premise of the decision that, I quote, a US prosecution would be reliant on the UK held evidence, reliant on it. Now, the long-established policy and practice of this country in dealing with MLA requests has been to seek death penalty assurances in such circumstances. But the Home Secretary sought no such assurances. He didn't even seek a limited assurance, which had been offered in the past, that the evidence would not be used directly, and that had been offered by the US Department of Justice in March 2016. And in doing so, we say the Home Secretary departed from the principal position of his two predecessors, both Theresa May and Amber Rudd. Just looking at the history, Theresa May requested a full death penalty assurance. We've set that out in the SFI at paragraph 12. That accorded, and that was on the 29th of October 2015, and that accorded with advice from her officials that, firstly, the provision of material without such an assurance, I quote, could place the UK in breach of the death penalty policy, and secondly, that, I quote, the US will be expecting this as it is standard practice. Then in March...
What's the number, the MS number for that, please?
892.
892. Thank you.
And then in March 2016, the US Department of Justice responded to Theresa May's proposal by offering an assurance of no direct use. That's set out in the SFI at page 229 of the MS, and also at paragraph 20 of Mr. Bigar's statement. That offer was not acceptable to the UK because it still left scope for the UK assistance to, I quote, lead to the death penalty being imposed and carried out. And that point was made again later, a year later, by the Home Office on behalf of Amber Rudd, when the request for a full assurance was repeated on her behalf. And of course, that was after Donald Trump had been sworn in as president in January 2017. So both Home Secretaries reiterated the UK's unequivocal position that, I quote, the UK will not provide formal mutual legal assistance in capital cases without a death penalty assurance. It was stated in the Home Office letter to the Department of Justice of the 29th of October 2015, and then it was repeated in exactly the same words in the Home Office letter of the 17th of August 2017 when Amber Rudd was Home Secretary. So far, so consistent. Then there was the capture of the suspects in January 2008, and of course they remain in the custody of irregular forces in northern Syria till today. At that stage, the CPS assessed that there was insufficient evidence to prosecute Mr. El-Sheikh, but we know from their response to the judicial review proceedings that the same was not true in the case of Mr. Cote, and indeed there was a charging decision made to charge him for 5 murders. Although it was being represented to the public, there was no evidence to prosecute either of them. As late as the 1st and 2nd of March 2018, Amber Rudd met the US Attorney General, Mr. Sessions. He suggested that the UK, not the United States, should in fact prosecute the 2 suspects. And obviously we agree with that. There is no suggestion that Amber Rudd was contemplating any alteration then to the established position of the British government of insisting on death penalty assurances. But then on the 16th of April 2018, the UKCA made a written submission to Amber Rudd maintaining its recommendation that the UK should seek a full assurance. My lady, it's at that point that opposition is voiced by US officials and the position begins to change. As set out at paragraph 22 of the note, on the 25th of April, the US Attorney General publicly stated to a Senate panel his disappointment that, I quote, "The British are not willing to try the cases, but tend to tell us how to try them." And then, when Sajid Javid, on the 4th of May, spoke to the Attorney General, Mr. Sessions indicated he was concerned that the UK was not interested in prosecuting Mr. El-Sheikh, and Mr. Sessions said the death penalty should not be an issue for the UK, and that he did not want the UK to, I quote, "tie his hands in relation to the use of the material." That, of course, my lady, led to the advice from the ambassador on the 16th of May, Sir Kim Darroch. He advised that a request for death penalty assurances was likely to provoke, I quote, "something close to outrage among cabinet ministers like Sessions, Mattis and Pompeo and senior political appointees." And he referred to the risk that they would, I quote, "wind the president up to complain to the PM and potentially to hold a grudge." That's at paragraph 27 of the SFI. The next step is that even despite that, and despite the ambassador's indications, the UKCA recommended on the 18th of May that the Home Secretary should maintain the UK's insistence on a full assurance. And in reaching this decision, the UKCA noted the Foreign Office warning that failure to follow the usual practice would undermine all future attempts to obtain death penalty assurances, and I quote, "would undermine Her Majesty government's death penalty policy globally, including in the US." And then we get the about turn after that. The Security Minister, Ben Wallace, on the 24th of May, notified the Home Office officials that his own final position was to make a strong recommendation that Her Majesty's government does not seek assurances, either full or direct use, around the death penalty. Now that followed a Home Office capping note, which we set out at paragraph 27, which assessed the three options, which are referred to in SFI at paragraph 36. And in the note itself, Mr. Bigger recommended a further attempt to obtain a direct use assurance. So he was still saying, first try a direct use assurance, but he did, it's fair to say, express his preparedness, if such an assurance was not forthcoming, to accept no assurances. And there was reference then to it being permissible under the policy. My lady, perhaps at that point I should take the court to the policy, which is at Appendix 2, page 424, and it's at MS 864. And yes, and if I can just take you straight to 9B, to 9A and B, of the OSJA policy, which was first issued in 2011, then reissued in 2014 and again in 2017, but with no material changes. 9A at
and
page 4.
What does OSJA stand for? Not everybody in the room will know these acronyms.
Overseas security and justice assistance. I'm so sorry.
Sorry, which is the MS number, please?
My lord, it's 864.
864.
864, MS 864. And does my lord have that?
Yes, I do.
Yes. So one can see there at 9A, under the heading death penalty, A, written assurances should be sought before agreeing to the provision of assistance that anyone found guilty would not face the death penalty. B, where no assurances are forthcoming or where there are strong reasons not to seek assurances, the case should automatically be deemed high risk, and FCO ministers should be consulted to determine whether, given the specific circumstances of the case, we should nonetheless provide assistance. So I think it's fair to say that that does contemplate that there could be exceptions. Now, can I just make these 3 points about that, if that is the correct interpretation of the policy? Firstly, the allowance for exception in our respectful submission undermines the whole policy and its rationale, which is the rejection of the death penalty in all circumstances as immoral and wrong. Secondly, it contradicts the public statements being made by our government, both to the UN and in their dealings with the US, where they repeatedly stress it is our policy to require death penalty assurances, not but there are exceptions. And finally, and this is the point that my Lord Kerr put to me, it is unlawful insofar as it breaches the principle that we should not, in any circumstances, facilitate or be directly instrumental in the imposition of the death penalty. And so those are our respectful submissions about the policy.
Can I just be clear? This document, 424, is an annex to a document which starts at page 404, is it?
My Lord, exactly. Yes.
Which is signed by Boris Johnson as Secretary of State, but he refers to the guidance being first put in place in 2011 by William Hague.
Right, yes.
Do we know whether that guidance was in the same form as 9B?
My Lord, it's almost identical. Yeah. I think it, for all purposes it was identical.
Yes, so
it's
this exception, which you say was unlawful, has been around quite a long time.
Yes. 2011, 2014, 2017.
Thank you.
My Lord, yes.
Are you, Mr. Fitzgerald, going to be explaining to us at some point something which I find a little puzzling about the facts? The American Attorney General was obviously keen that Mr. El-Sheikh should be prosecuted in Britain.
Yes.
And of course he's a British citizen and he's accused of having murdered British citizens. But the British ministers were anxious that he should be prosecuted in the US. Are you going to be explaining to us why ministers weren't prepared to prosecute him here?
Well, my Lord, they accepted the advice of the CPS, which is now the subject of a separate challenge. My Lord, can I just, because it is of some relevance to the issues of necessity, that are relevant to my learned friend Mr. Hermer's point.
I see, you're going to come on to it later.
Well, my Lord, just so that I deal with it head on, what we respectfully say is the evidential point that there is no evidence on which there could be a prosecution of Mr. El-Sheikh has gone. He could be prosecuted here, albeit they say they don't have enough evidence to prosecute him for murder yet. They could prosecute him for membership of a terrorist organisation. That's now accepted. So Mr. Al-Kote, it was being said that neither of them could be prosecuted. Mr. Al-Kote, there's a charging decision that he could be charged for 5 offences of murder dating back some time. Mr. El-Sheikh could be prosecuted here, although they're saying we haven't yet got enough evidence to prosecute him for murder, and that may be because the evidence just doesn't exist. The second justification put forward is, well, we couldn't get him here lawfully. That is absolute and ridiculous in our respectful submission. They have volunteered that they would come here voluntarily. the principle that you can't extradite you can't extradite without an extradition treaty only applies where there is an extradition treaty. And people have been returned from lawless states without extradition arrangements. And if it's said, well, there might be an abuse argument, cross that bridge when you get to it. But just remember the case of Warren, where it's said that you always balance any breach of the rule of law against the enormity of the crime. And we respectfully submit, with great respect to the CPS, that it just doesn't bear scrutiny, this proposition. But I accept that's not the central point in these proceedings.
Well, it's an entirely incidental issue, but can you say in a sentence why it was believed that they could be prosecuted in the United States but couldn't be prosecuted here?
My Lord, it may be because the US takes a slightly more relaxed view to how you get into the US. There's the Alvarez-Machin doctrine, whereby even if you're kidnapped and taken to the US...
So it's just getting them back to the jurisdiction?
That appears to be because I would have thought the rules of evidence, the common law rules of evidence, are the same in both jurisdictions. Yes. And we've got the evidence. We've got 600 police statements. So, my Lord, I know it's only... But if it is a matter that deeply disturbs us in these proceedings and is the subject of a separate application.
Well, I see it's not directly relevant, but you've said that the US proceedings will be dependent on the British evidence. Have the US got separate evidence to add to the British evidence, do you know?
My Lord, they may well have some separate evidence, but they are saying that the Secretary of State was saying the US is reliant. And indeed, the Sessions said they have evidence which we need for prosecution.
Well, presumably, since Mr. Sessions was keen that they should be prosecuted here, any evidence reposing in the hands of the American authorities would presumably be given to the British authorities.
Yes, of course, my Lord, there's no question of that. My lady...
That then poses the question, does it not? If they've got similar rules as to the standard of proof, what is the basis of saying you can prosecute in the US and you can't prosecute here?
Well, my Lord, that is the subject of a separate judicial review. Of course, this is the Supreme Court. If the Supreme Court expressed its view, it would be of great value, because at the moment leave has been refused. But I have to say, it defies all common sense and legal logic that they can be tried in America on our evidence, but they can't be tried here on our evidence. It simply doesn't make sense. And the only thing that one can come up with is that there is this more relaxed view about the legality of route to the place of trial, but we have the Warren principle here, which indicates that even if there were some technical breach in the rules in the way the person arrived here, although they're voluntarily saying they'll come here, that you always, in an abuse application, weigh the gravity of the crime against the gravity of the breach. And it wouldn't be a very serious breach if they were saying, we want to come back, we laid on a plane, they flew back, and then they said abusive process. You can imagine how successful that would be applying the Warren principle. It wouldn't have a snowball's chance in hell, quite frankly.
It's really a non-issue as far as I'm concerned.
Sorry, my Lord. Okay, I'm going to move on. The capping note, you have it. The Home Secretary's own decision. On the 29th of May, the private secretary, the Home Secretary, recorded the Home Secretary had indicated his agreement to seeking no assurances. On the 30th of May, there was a meeting between the Home Secretary and Attorney General Sessions. At that meeting, the Home Secretary indicated that he currently intended not to ask for death penalty assurances. We are told by Mr. Bigger that this was because the Home Secretary believed that if he asked for assurances, it was likely to prompt the sort of outrage he had been advised of. So in that meeting, the Home Secretary abandoned even any attempt to hold the US to the limited assurances that had already been offered. And on the 31st of May, there followed the FCO internal submission that option A should be sought. Option A was to obtain a full death penalty assurance. The submission confirmed this is the recommended option by FCO and Home Office officials. And that was because it was consistent with the general expectation set out in Her Majesty's government's policy and I quote, consistent with all past practice when dealing with the USA MLA requests. So right to the end, the basic recommendation of the UKCA and of officials at the Home Office and the Foreign Office had been to press for a full assurance. But the Home Secretary did not follow that recommendation. On the contrary, on the 11th of June, he wrote to the Foreign Secretary indicating his view that, I quote, significant attempts having been made to seek a full assurance, it is now right to accede to the MLA request. Well, no attempt had been made to seek a full assurance, as we know from history. And in that letter, he sought the views of Boris Johnson, then the Foreign Secretary, and in his reply of the 20th of June, the Foreign Secretary agreed with the Home Secretary. He recognised that there was a serious risk that providing the assistance would directly or significantly contribute to the imposition of the death penalty. That's SFI para 46. And he recognised that this decision, I quote, presents a risk of damaging our ability to secure adequate assurances from the US and other countries in the future. Then on the 22nd of June, the Home Secretary wrote to the US Attorney General. He communicated his decision to provide mutual assistance. He indicated that, I quote, there are strong reasons for not requiring a death penalty assurance in this specific case, so no such assurances will be sought. The crucial reasons were the need to bring foreign fighters to justice, the insufficiency of evidence to prosecute in the UK, and the fact that a US federal prosecution is more likely to be possible. But he referred to the, I quote, long-held position of the UK to seek death penalty assurances, and he emphasised that our decision in this case does not reflect a change in our policy on assistance in US death penalty cases generally. There's a bit of Pontius Pilate about that. I wash my hands of all this. But we maintain our policy purely, but we depart from it to assist you. We've got the cross, we've got the soldiers, but you carry out the execution.
Could I just ask, reverting to your paragraph 29, if it transpires that the single motivating or actuating factor in the mind of the Home Secretary was his apprehension of outrage on the part of the authorities in America, if that was the single factor which motivated the Home Secretary, is it a consideration which was material to his decision, or should it have been left out of account?
My Lord, we would say that that would go to the rationality of the decision. My Lord, I think I have to draw the Court's attention at the bottom of page 19 of our note. The crucial reasons were the need to bring foreign fighters to justice, the insufficiency of the evidence to prosecute in the UK, and the fact that a US federal prosecution.
Thank you.
So it was, they must be prosecuted, that's the necessity. We won't prosecute because the CPS have advised we can't. Therefore, the only way to bring them to justice is through a US federal prosecution. Even were that the case, we say, well, that doesn't stop you insisting on our policy, and we say that what the common law requires, a death penalty assurance.
And that's so even though the result may be they won't be prosecuted anywhere.
My Lord, yes, in the final analysis, but that's not...
That's the balance you've got to draw.
My Lord, yes, but of course, one has to bear in mind that in the Al-Musawi case, France and Germany insisted on assurances before providing evidence in numerous cases. I appreciate one has to look at the realities, but it would be an extraordinary position to say, though we believe that they should be brought to justice, and though we're prepared to bring them to justice, because of the insistence which is common throughout the Western world of no death penalty, we won't bring them to justice. I mean, after all, life without parole in ADX Colorado is a pretty severe punishment.
Yes, but I mean, we, for good or ill, have to accept the position that, as far as the Home Secretary was concerned, they're not going to be prosecuted here.
Yes, that was the basis of his decision.
That's the basis of his decision.
Yes, I accept.
And so we can't go behind that.
I accept. Well, then that's why I drew attention to it.
And so if the US's position was they're not going to prosecute without our assistance and they're not going to give the death penalty assurances, then they're not going to be prosecuted.
But, my Lord, it was never as clear-cut as that. I mean, that was simply a fear that they might take that.
No, but I mean, that is the way the the Home Secretary reasoned it, and we presumably got to take that at face value.
Well, my Lord, I think one can probe as to whether enough attempts were made to seek an assurance. My Lord, I know that that's important in my own friend Mr. Herman's case on proportionality.
Yeah.
But because a direct use assurance had already been volunteered in 2015. And the recommendation of the civil servants was go back and try and get it again. And he simply didn't try. And my Lord, the conclusions on ground one then are, firstly, this was a departure from our settled policy. Secondly, the actual trigger was undoubtedly the anticipation of a hostile reaction from the US to any maintenance of our position. And as a matter of historical fact, the abandonment of the request for assurances followed on from Mr. Sessions' public statement on the 25th of April and the ambassador's assessment. And thirdly, not only did we not seek full assurances, we did not even seek any limited assurances. I think that the United States would abstain from direct use. My Lord, that I hope that third point perhaps answers your Lordship's point to some extent. The legal consequences, we say that irrespective of that history, the Home Secretary wrongly exposed the suspects to the very real risk of an inhuman punishment. It was wrong because this country should not facilitate the imposition by another country of a punishment we ourselves recognise to be inhuman and unlawful. We say that the death penalty itself can now be seen to be an inhuman and unlawful punishment, and therefore it is unlawful for the state to take any positive and formal act that facilitates its imposition. A state facilitates the imposition where it does something that is directly instrumental in bringing about the death penalty. That is something that significantly contributes to causing the imposition of the death penalty. The causal connection is not really in doubt, and we've set that out at 3.2 in the case. It was admitted by the Home Secretary that the prosecution in the United States would be reliant on the evidence to be provided by the US. This means that a successful prosecution depended on the UK's evidential assistance. Moreover, the Divisional Court made an express finding that the fact of facilitation was made out, and that's set out at paragraph 47 of their judgment. We say that the decision to provide the evidence without death penalty was also irrational because it undermined our publicly declared opposition to the death penalty in all circumstances, and because it contradicted our own public and unequivocal statement to the UN General Assembly that we do not provide mutual assistance in capital cases without assurance. My Lady, there is an application to admit new evidence. It's not opposed, though there are remarks made about its relevance. I do respectfully submit that it is relevant that this court should have the full picture, and the 2 points that we make, and they're set out at paragraph 43, is that there was a historical decision in February 2016 that there was sufficient evidence to charge Alexandra Cote here with 5 offences of murder and 8 offences of hostage-taking, and further that warrants were then issued for his arrest. In respect of Mr. El-Sheikh, the new evidence further shows that the DPP now concedes that there may be sufficient evidence to charge and prosecute him here, at least for offences of membership of a prescribed organisation. My Lady, the maximum sentence I accept is 10 years. But the principal ground on which the DPP now declines to prosecute here is the alleged unavailability of a mechanism for returning the suspects lawfully to the UK, and the court has had my submissions on that. That we say that the evidence does tend to undermine the major justification put forward by the Home Secretary for providing the United States with evidence without an assurance. The justification was that the suspects could not be prosecuted in the UK and therefore must be prosecuted in the United States. And now it really is down to the reason they can't be prosecuted here is the problems with the route by which they would return. My Lady, if I can then very briefly go on to take the court against that background to our key propositions, and I hope I can take them quite shortly. Firstly, on the facts, we have, at part 3, you have really the narrative of the facts I've taken you through. The causal matter is not in dispute at 3.2. the provision of assistance is contrary to past practice at 3.3, page 270 MS. The policy lays down a standard practice of seeking death penalty assurances, and we've made the point that this appears to be the first time since 2011 there's been a deliberate decision to depart from the standard practice. We've dealt with that in some detail, my lady, in the reply, but I won't take time with it now. But we say it's the first time anyway that it's been acknowledged that there has been a departure since 2011. You have the point about the initial approach of Theresa May and Amber Rudd being consistent with our long-established and principled position, and the departure from that position being triggered by the US indicating their dissatisfaction with us asking that there be no death penalty. Fifth, the decision was taken against the advice of officials in both the Foreign Office and the Home Office. Of course, we accept the decision makers entitled to not follow advice given by officials, but we say it's relevant. Sixthly, the decision undermined the UK's unequivocal and publicly known position of absolute opposition to the death penalty, and that was why the Foreign Office said that it would undermine our death penalty policy globally. Seventhly, it was prompted by the likely reaction from the US officials, well, high-up officials. The point was made that the normal US diplomats, the State Department, would expect it of us, just as they expected of France, Germany, and many other European countries. It was the reaction of high-up political appointees, and in particular Mr. Sessions and Mr. Pompeo, that was the cause of concern. We've made a point about Guantanamo. I don't pursue that, my lady. It's just, but we accept one of the concerns was, well, they may say a plague on the whole business, we'll send them to Guantanamo. But we say that there was no assurance that they would not go to Guantanamo's sword. Ninthly, my lady, we've set out the evidential points at 3.10 that there was criminal charges authorised against Alexandra Cote, that the British police do have evidence, very, very substantial evidence, that they have expressed their desire to return voluntarily, and therefore we question whether there was any necessity at all to expose them to the risk of the death penalty in order to avoid impunity. And then the suspects, we make the point, have substantial links to the UK, born in the UK, both British citizens at the time of their alleged criminal conduct, and some of their alleged victims were British citizens, and there was this extensive investigation by the police in this country. And finally, in reaching this decision, the Home Secretary failed to have regard to the specific death penalty regime that applied in the United States and the near universal condemnation of the long periods inevitably spent there on death row awaiting execution. We have the undisputed evidence of Professor Fagan is that the average period awaiting execution is 12.5 years. It can be many, many years more, as long as 30 or 50 years, and we've referred the court respectfully to Justice Breyer's dissent in Glossop and Gross. My Lord, just by way of footnote, you can see that Mr. Zagorski was executed after 34 years, I think, on death row, and he was so concerned about the uncertainty of the method by which he would be executed that he actually volunteered to be executed by the electric chair. And that leads to my final point. The execution will be by lethal injection, which, in Professor Fagan's view, creates a substantial risk of extraordinary and intolerable pain and suffering, and a torturous, gruesome, and disfiguring execution. And we have quoted the points made by Justice Sotomayor in her powerful dissent, joined by 3 justices, the proven likelihood that the lethal injection in Tennessee would inflict several minutes of torturous pain on an inmate. She, in fact, referred to the execution by lethal injection as potentially akin to being burnt alive at the stake chemically. And we've quoted that later on. And finally, you have Justice Breyer's dissent in Glossop and Gross, showing the arbitrary nature of the imposition of the death penalty, the fact that racial factors can often play a part. And we say that that whole picture of the death penalty regime simply wasn't factored in. It's now said, well, he's now considered it and said it wouldn't have made any difference. But that's always difficult to fathom. Now, my lady, if I can just then summarize, we say firstly, the death penalty per se is and can now be seen to be contrary to the common law and the Bill of Rights. Secondly, that therefore we shouldn't facilitate it, either by extradition or by providing evidence. And thirdly, we respectfully submit that the Divisional Court's reasoning in relying on the cases of Sandiford and Zagorski was misconceived. Those decisions are readily distinguishable as correctly decided, but simply not providing principles that are applicable in this case. The facts were totally different. There was no question in either the case of Sandiford or in the case of Zagorski of the UK being directly instrumental in the causation of death. So that's a summary, my lady. But if I can take you to the legality of the death penalty per se at part 5 of our case, obviously, I know that in the case of Sandiford and the other cases assembled at 5.2, it's been clearly established that an exercise of the prerogative power is reviewable on grounds of legality as well as on grounds of rationality. Sandiford is perhaps the most readily available at Volume 1, Tab 10, paragraphs 65 to 66. Unless the court wishes me to take you to it, the principle is, and I know that my Lord Carnwath will be well familiar with, having given the judgment in that case, the principle established in other cases, including the Chagos case, that the prerogative is reviewable. Now, as to this case, there may be no domestic authority directly on point, but we say there are relevant and established principles of law that should govern the exercise of the Home Secretary's powers. My lady, we have cited from Lord Carswell in A, and perhaps I could just take the court very briefly to that Volume 3 at tab 34. How does the common law develop? In a situation such as this, bearing in mind that my Lord Reid has made the point in Osborne, and it's been made again by Lord Mance in the case of Kennedy, that very often the common law goes just as far or even further than the European Convention in the protection of fundamental rights. And so we submit that it is of assistance to look at Volume 3, tab 34, Lord Carswell, and there, of course...
Page?
At page 2638, my lord. Okay. 2638. Does my lord have...
Yes.
Yes. So one sees there that he's looking at the question of evidence obtained by torture being deployed in judicial proceedings. He cites the famous judgment of the Supreme Court of Israel about, although a democracy must often fight with one hand tied behind its back, it nonetheless has the upper hand. Preserving the rule of law and recognition of an individual's liberty constitutes an important component in its understanding of security. And then he says, how do we give effect to this moral imperative in our law? And he says that at 152, some of your lordships have expressed the opinion that the common law as it stands would forbid the reception in evidence of any statement obtained by the use of torture. See the opinions of my noble and learned friends, Lord Bingham and Lord Hope. This view may well be justified historically, but even if it requires some extension of the common law, I am of the clear opinion that the principle can be accommodated. We have long ceased to give credence to the fiction that the common law consists of a number of preordained rules which merely require discovery and judicial enunciation. 2 centuries ago, Lord Kenyon recognised that in being formed from time to time by the wisdom of man, it grew and increased from time to time with the wisdom of mankind. And Sir Frederick Pollock talked about the freshly growing fabric of the common law. And then there's a citation of Justice Matthews in Hurtado in California. As it was the characteristic principle of the common law to draw its inspiration from every fountain of justice, we are not to assume that the sources of its supply have been exhausted. On the contrary, we should expect that the new and various experiences of our own situation and system will mould and shape it into new and not less useful forms. And finally, the citation from Peter de Ponceau: its bounds are unknown, it varies with a succession of ages. It takes its colour from the spirit of the times, the learning of the ages, and the temper and disposition of the judges. And then going on, Lord Carswell formulates this helpful principle: I'm satisfied that whether or not it has ever been affirmatively declared the common law declines to allow the admission of evidence obtained by the use of torture, it is quite capable now of embracing such a rule. If that is in any extension of the existing common law, it is a modest one, and then this we rely on, a necessary recognition of the conclusion which should be drawn from long-established principles. And my Lord Carr put to me, forget the policy. If we are committed to the proposition that the death penalty is a cruel and unusual punishment within the terms of the Bill of Rights, or an inhuman punishment, is it not a necessary recognition of the conclusion that we therefore shouldn't be directly instrumental in the facilitation of it, either by extradition or by providing the evidence without which a capital prosecution cannot take place? And my lady, that's our basic proposition. We make the point at 5.5 that the Bill of Rights is still there. It's still vigorous. Can I just give you 2 quotations? In the case of Boodram, Lord Zinn described it as a constitutional document creating fundamental rights. That's in Boodram and Baptiste, which is in the extra bundle behind the reply. And I give you the reference, it's 1711 G to H. And in the case of the HS2 case, Lord Sumption said, the UK has no written constitution, but we have a number of constitutional instruments. And he referred, that's at paragraph 207, and he referred to the Bill of Rights as such a constitutional instrument. It's clearly capable, it's an always speaking statute, which develops with the passage of time. There's a judgment to that effect by Mr. Justice Kennedy in the ex parte Reed, recognising that. But Lord Stayne is effectively saying the same in the case of Rudall, citing from the case of Ireland, where he says there are certain statutes which are always speaking statutes which develop with the passage of time. The meaning he attributed. Therefore, we say...
Statement in the HS2 case, I think, was by Lord Mance and Lord Newberg and Lord Mance.
I'm so sorry. Have I
it doesn't matter.
Have I got it wrong? Yes.
In the judgment, which I think
but
was agreed by the rest of the court.
Yes. Yes. But I know your lordship gave one of the leading judgments.
No, I didn't say it.
In
HS2, I just thought
yes.
just for the sake of form.
Yes. Well, my lord, what we do respectfully submit is that this is exactly what my Lord Reed was talking about in Osborne and Lord Mance was talking about in Kennedy, about we don't have to look necessarily to the European Convention when we've got our own laws, the Bill of Rights, which outlaws cruel and unusual punishment. And the logical consequence of that, we say, is that the common law should not permit the infliction of that which our own law would recognise to be a cruel and unusual punishment. My lords, then really, can I then just, why should this court conclude that the death penalty is cruel and unusual? And we've set out our, I think, 8 reasons at 5.7 onwards. Firstly, because the European Court of Human Rights has developed the principle in Al Sadoun, and we've quoted that. My lady, can I just, rather than going to it, can I just so that they conduct an analysis there leading to the conclusion that the use of the death penalty negates fundamental human rights. and constitutes human and degrading treatment. That's at paragraph 120. And can I just draw attention also to, in that Al Sadoun judgment at paragraph, let me just give you the reference to Al Sadoun. It's tab 14 of the first bundle of authorities. There's a recognition, so 115 deals with it being a cruel and unusual punishment because it essential that the abolition of the death penalty is essential for the protection of his right and the full recognition of the inherent dignity of all human beings. And at 118, page 1813 of the MS, it is, they refer to the right not to be subjected to the death penalty, ranks along the rights in Article 2 and 3 as a fundamental right, enshrining one of the basic values of democratic societies, making up the Council of Europe. And then finally, if I can just take you to paragraph 124, MS 1816, the last sentence, where they're talking about the liability under the Convention. It is liability incurred by the contracting state by reason of its having taken action, which has as a direct consequence the exposure of an individual to the risk of prescribed ill treatment. We say that fits this case like a glove, that underlying principle. Now, there's clear authority, again, by Lord Reed's judgment in Osborne, that the Convention principles frequently, and we would say a fortiori in this case, have homonyms in domestic law. And this is clearly such a case. It's unthinkable that we lag behind the European Convention in the prohibition of cruel and unusual punishment, given the role that this country has played in the development of that prohibition ever since 1688. Secondly, the European Union has itself categorically condemned the death penalty as absolutely wrong in all circumstances. Thirdly, Parliament has taken the lead in abolishing the death penalty, repeatedly rejecting its reintroduction. Can I just give you the reference there to, in Burns, the Canadian Supreme Court case, which is behind our reply. Can I just give you the reference? At page 329, the Canadian Supreme Court said that the significance of Parliament's rejection of the death penalty for the law was this, I quote, "The fact that successive governments and Parliament over a period of almost 40 years have refused to inflict the death penalty reflects a fundamental Canadian principle of justice." So one can draw on parliamentary history and the reasons for the rejection of the death penalty over the decades to identify a fundamental principle of justice. And they described it as a Canadian fundamental principle of justice. Fourthly, there is a significant fact of the UK's ratification in 1999 of Protocol 6 and in 2004 of Protocol 13. And I would add the signature in 1999 of Protocol 2 of the ICCPR, which commits us to the abolition of the death penalty also. So even if you took away the European Convention, you'd still have that commitment.
Yeah. Can I just ask you this? Because you referred to my judgment in the Sandiford case.
Yes.
And there we were drawing a distinction between judicial review in the sort of ordinary case of statutory powers and judicial review of the exercise of prerogative. And we said that obviously prerogative is reviewable, but in that case it would be done against the practice or policy governing the exercise of that prerogative. And that's obviously an important limit of your case here. But you're now on a sort of slightly broader principle, is the development of the common law as a sort of legal constraint on the exercise of the prerogative in foreign policy. Is there any sort of precedent or authority that supports that sort of application of the common law, the development of the common law in that sort of context?
Well, apart from Banku, the right not to be exiled being read into the exercise of the prerogative, that would be the best example, I think.
The
Banku, number 2, I think.
I see.
The right not to be exiled is a fundamental British right, which was read into the exercise of the prerogative. But my Lord, my Lord,
have that in the,
I think it is there. I think, yes, my Lord, it is. Yeah. But my Lord, can I just, without relying on Banco itself, my Lord, our proposition is that the exercise of the prerogative powers is subject to a principle that it should not be exercised in a manner that offends against fundamental principles of the
No, I understand, that's what you're saying.
So, for example, my Lord, supposing in some remote island, which is not subject, we were to say we're exercising the prerogative and authorising the death penalty, the Bill of Rights would say you can't do that. You just can't do it because it's a cruel and unusual punishment. And we would say that would be an unlawful exercise of the prerogative if it was by statutory instrument. My Lord...
Yes, that's by virtue of a modern interpretation of the Bill of Rights. Rather than, yes.
Yes, well, we also say that fundamental principles of the common law. Now, my Lord, I accept that in the Sandiford case, your Lordship said that the doctrine of fettering discretion, which applies to normal exercise of statutory powers, doesn't apply to the prerogative. But this is something more fundamental that we're asserting here. And, my Lords, could I just press on with the list? So that because this may be of importance too, which at 5.11, we would say that developments in international human rights law are clearly relevant, and that's where we submit that the fact that the United Nations Human Rights Committee has developed a principle that one should not be instrumental in the causation of the death penalty if one is an abolitionist state is of great relevance to the question of whether the prerogative could be exercised in a manner that was inconsistent with our commitments under the ICCPR. My lady, we have developed that in our note on the United Nations Human Rights Committee, and just very briefly, if I can show the court that at part 3, sorry, on page 3, we rely on the analysis of Christoph Haynes, the former special rapporteur, and
You identify this note, please.
sorry, shall I just give you the ref?
Yes, but I think my Lord is asking for the identification of the
No,
note.
it's called Appellant's Note on Guidance from the UN Human Rights Committee.
On the status of the death penalty under
Yes.
ICCPR and on the principle of
My lady,
non-facilitation of the death penalty by abolition.
Well, I can-
Well, I
states.
have it. Thank you very much.
Yes, if anybody doesn't have it, I'm sure we've got a yes. But my Lord,
He
Lord.
does.
I don't, I'm afraid.
You're just taking you back one point, if I may, before we go into this.
My Lord, yes.
You referred to the UK ratifying both Protocol 6 and Protocol 13. Am I right in saying that Articles 1 and 2 of Protocol 6 and Article 1 of Protocol 13 are articles under the Human Rights Act as well?
Absolutely right.
Is correct.
You're
So-
absolutely
So
right.
they're part of our domestic law as well?
Yes, they are. Yeah, your Lordship's absolutely right. Yes, they're incorporated. Well, just if I could just take you to the to part 3 there, one can see. Well, can I just take you to 2.3 in the note? The case of Judge in Canada. The committee stated, and it's in bold, for countries that have abolished the death penalty, there is an obligation not to expose a person to the real risk of its application. and that was said in the context of deportation or extradition, but then one sees that in general comment number 36, which is part 3, it stated that the concept of jurisdiction extends to include the protection of persons located outside any territory, effectively controlled by the state, whose right to life is nonetheless impacted by its military or other activities in a direct and foreseeable manner. And then one sees, so that's general comment 36, which is regarded as an authoritative guidance on the meaning of the ICCPR. And Haynes refers to the principle in Judge in Canada that an abolitionist state should not provide the crucial link in the causal chain that would make possible the execution of the author. And he makes it clear that this principle extends beyond situations of extradition. And he shows that the prohibition of extradition, it should be from an abolitionist state, is merely a manifestation of the broader requirement on abolitionist states not to facilitate the imposition of the death penalty on persons under its jurisdiction in other countries in a direct and foreseeable way. And that extends to the provision of intelligence or incriminating evidence. One sees that in his 2012 report as UN Special Rapporteur set out at 3.5, and his 2015 report that bilateral or multilateral assistance in the legal process leading to a death sentence could make a state responsible for the imposition of the death penalty in another state.
Ms Fitzgerald, I'm sorry to interrupt you, but just in answer to Lord Hodges' question a moment ago, I've got the Act in front of me, and it seems that Article 6 does, I beg your pardon, the 6th protocol does not form part of Convention rights, but Article 1 of the 13th protocol does.
Yes, it does, because, I'm so sorry, that's because that is the abolition in all circumstances, including war.
Yes, it effectively supersedes the earlier one.
On my copy from the government legislation, it seemed to refer both to Article 13, Protocol 13 and Protocol 6, but
I think my Lord, I can do a note on that because I think it may originally have been the case, and then
Protocol 6 and then Protocol 13.
Then Protocol 13 took over, yes. But I think that is right, because there's a case called St. John which deals with that. If we go on from there, we say, applying the principle that you can draw from all fountains of justice, you can rely, we say, on the US Supreme Court dissents in Furman in Georgia and Gregg in Georgia, and on Justice Breyer's dissenting opinion in Glossip. And as early as 1972, Justice Brennan in Furman, this is at 5.14, death is an unusually severe and degrading punishment. There is a strong probability that this is inflicted arbitrarily. Its rejection by contemporary society is virtually total, and there is no reason to believe that it serves any useful penal purpose. The same by the South African Supreme Constitutional Court in Makwenyana in the judgment of the President, Chaskelson, and we've set it out there, annihilates human dignity. Elements of arbitrariness are present in its enforcement, and it is irremediable. And then finally, we draw attention to the case of Wellington, where in the Divisional Court, Lord Justice Laws talked about the death penalty being inconsistent with the inalienable value of the life of every person. Lord Hoffman in the House of Lords, and I know that my lady was party to that judgment, taking a more pragmatic but equally ethical view, that was on the basis of its irreversibility, its lack of deterrent effect, and the degrading effect of the ghastly ceremony of execution on both the participants and the society on whose behalf it is performed. So, my lady and my lord, just drawing back from it for a moment, we say from those sources, ethical, judicial, political, domestic and international, this court can draw the conclusion that the common law of England has evolved to recognise that the death penalty is a cruel, inhuman and degrading punishment per se, and it would obviously be also contrary to the Bill of Rights. Moreover, that will accord with and reflect developments in the approach of our own Parliament and the Executive. And that's why Lord Dyson said in the Court of Appeal in Sandiford, the death penalty is, in my view, rightly regarded by the government as immoral and unacceptable. And that's why we submit at 5.17 that it's unlawful exercise of public power to impose the death penalty or knowingly and directly to facilitate its imposition. We've set it out in more detail, that basic principle. Now, the final matter I'd need to deal with is the question of the non-facilitation principle. At part 6, we've identified that my Lord Kerr, in the Ismail case, looking, and this is at 6.2 on page 283 of the MS, looking at the Suring principle, identified as what was underlying that was the UK's facilitation of inhuman and degrading treatment by the United States. And my Lord said this, it was because of the UK authorities, and I admit he said in extraditing, facilitated that outcome that a violation of Article 3 was held to be present. In effect, the UK would have been directly instrumental in exposing Suring to the risk of being executed. And that same principle is in Al Sadoun, which we've quoted, paragraph 124. The court endorsed the principle liabilities incurred by a contracting state by reason of its having taken action, which has as a direct consequence the exposure of an individual to the risk of prescribed ill treatment. And general comment talks about states parties that abolish the death penalty cannot deport, extradite, or otherwise transfer. And if we look at the underlying reasoning of the case of Mohammed, 6.4, in the Constitutional Court of South Africa, the court there held that one could not extradite to face the death penalty, and their reasoning, and it's set out in the middle of 6.4, is the commitment implicit in the Constitution of South Africa that it will not be party to the imposition of cruel, inhuman, or degrading punishment. So any complicity, we say, of a directly instrumental nature, whether it be by extradition or by the provision of evidence, falls within that test. And again, if we look at the United Nations Human Rights Committee's decision in Judge in Canada, they talk about the actions of Canada, that was before the Burns decision, establishing the crucial link in the causal chain that would make possible the execution. So it's because your action is directly instrumental or causative of the exposure to the death penalty that the extradition principle is formulated. And therefore, the principle is wider than the example of extradition. The underlying principle is that the state should not be directly instrumental in the causation of the death penalty or in exposure to the very real risk of the death penalty. And that's the same principle that one sees in paragraph 102 of the Special Rapporteur's report of 2015, which we've set out at 6.5. That's that states that have abolished capital punishment may not assist in bringing about the death penalty in other countries. So that's the underlying principle, and we say...
Mr Fitzgerald, Lord Reid would really like to ask you a question.
I'm so sorry, my Lord. My head has been down and I've been totally unresponsive.
Your head has been down and you have been in full flow, but just occasionally we do have to interrupt you.
I'm so sorry, my
Well,
Lord. I'm so sorry, my Lord.
I've been looking at the Canadian case of Burns and the South African case, and in the Canadian case, it's a charter case. They decided to rest their analysis not on cruel and degrading treatment, but rather on the Article 7 of the Charter, or Section 7, which guarantees the right to life, liberty and security of a person. And their reasoning, put shortly, was that if you put it on cruel and degrading, they felt that there was a greater problem in relation to cruel and degrading treatment to do with the directness of the link between the conduct by the Canadian government and the treatment suffered.
Yes, I see.
One can see, for example, if you are providing a piece of evidence, there may be an issue about whether doing so has such an impact on the procedure that it in itself renders you guilty of or complicit in cruel and degrading treatment. The Canadian court, at any rate, thought that, I haven't analysed it, but they seem to have thought that one could lessen that problem by relying on the right to life, liberty, and security.
We may not have that luxury. We may not have that option. But, my lord, if taking that the causal point, if in the extradition cases, which really is now so well established universally in Western democracies, that I think one can properly say it no longer depends simply on the Human Rights Convention. The underlying principle is we should not be causative of the death penalty, although, of course, the same points could be made. What we do in extraditing is not to try the person, is not to convict the person, is not to sentence the person, is not to execute the person, but to be part of the causal chain whereby that is set in motion. My lord, actually, this is a stronger case because we are there. This is prosecution by proxy. This is, we are providing those 600 prosecution statements, which are an integral part of the causation of the conviction in the capital trial.
Well, one way of approaching this question, whether or not it is instrumental, is to ask oneself the question, would Mr. Sheikh be exposed to the risk of the imposition of the death penalty if we did not provide the material? The answer to that is no. I'm not saying that it is necessarily, but if the answer to that is no, then I assume you would argue that it's impossible to suggest that it is other than instrumental that the provision of the material contributes to the possibility of the imposition of the death penalty.
My lord, that would be my respectful submission, and that therefore, because it's inhuman treatment that you're exposing the person to in the convention case law, and in the South African case law, I think it's inhuman treatment as well as the right to life. But what we would submit is that the evidence is there here. They're saying, Sessions is saying, you have the evidence, we need it. And there's a finding which we've actually recorded at 3.2 of the case. The Home Secretary recognised that, I quote, a US prosecution would be reliant on UK held evidence. Reliant on. So that would be the but-for test satisfied. And if we go on, the Foreign Secretary, a serious risk that providing assistance would directly or significantly contribute. So they were directing themselves, fairly, if I could say so, on the basis that causal connection was made out. And that's
well, my Lord's analysis, which I'm sure is right, of the Canadian case is that they didn't have to confront directly the question of whether it was instrumental because there was another route to achieve the same objective. Here, it may be said that we do have to confront it directly, but once you pose the question, would there be exposure to risk of the imposition of the death penalty without this evidence? And if the answer to that is no, then the provision of the evidence, you would say, is quite clearly instrumental in invoking that risk.
Yes, if the provision of the evidence is essential, or as it's said at 3.2, the US prosecution would be reliant. That must mean it's causally necessary, and directly. Then I would respectfully answer the thing: we are directly instrumental, and really trying to deal with my Lord Reid's point. I respectfully submit that in those circumstances we are just as much inflicting the inhuman punishment, as in the extradition cases, because in both cases it can be said, well, we don't do it ourselves. It's another country that does it. But actually, in this situation, we are more intimately involved in the trial process than in extradition. You just deliver the person there, and what happens later, whether they do a plea deal or is. But here, we're sending the person there knowing that there is likely to be a capital trial which will be reliant on this evidence. And so we say that is just as much facilitating as in the extradition case. And so we respectfully rely on the reasoning of those various sources to justify the development of the common law and or the Bill of Rights. I mean, my lord, my lady, I'm so sorry, my lady, the question of whether, in fact, we are in fact inflicting a cruel and unusual punishment by being directly causal to it, I don't think is necessary proposition for me to make, that we are actually inflicting it ourselves. But we are sufficiently contributing to its infliction that it's contrary to a basic norm enshrined in the Bill of Rights and in the common law. We respectfully submit. My lady, I think then really what I need to do is, turning to part 7, to just identify the flaws in the divisional court's reasoning. The divisional court's, and this is at part 7, page 286, the divisional court's first point was that the non-facilitation principle should be confined to extradition and expulsion cases. We respectfully submit that the reason why it has so far been so confined in the European Convention cases is because of the territorial limits of the European Court. And that was recognised in the Sandiford case, that there are limits to the protection which are, yes, one can see that at 6.7 of our note. The reason in the context of the convention is the person who invokes convention protections must be within the jurisdiction of a convention state at the time of the injustice he complains of. That's 285. This is clearly stated in the Supreme Court's judgment in Sandiford. That's my Lord Carnwath's judgment. But this jurisdictional limit, the invocation of the convention, does not inhibit the development of a wider domestic law principle that focuses on the fact that the actions are those of the UK and the consequences are the same: exposure to the prescribed form of ill treatment. So we say, firstly, that the fact that it's so confined in European Convention case law is a product of the limited approach to jurisdiction in the European Convention, which of course is a document dating back to 1950. That doesn't mean that the common law can't develop further. Their second point, and we've set that out at above 7.3 at page 287, is that the Human Rights Act set the limits of any developments in this area when it gave effect to the European Convention, with the accompanying territorial limits to the application of the Convention, i.e. you have to be within this country, which you are when you're extradited or deported, but you are not in this case where the evidence is provided. And then it held that it was wrong to develop the common law in a matter not sanctioned by the relevant statutory provisions. But the Human Rights Act itself contains no express or considered limitation to the developments of the common law principles in respect of the non-facilitation of the death penalty. It's too general a statute to serve such a function. And we there do respectfully submit that my Lord Reed's remarks in Osborne, Volume 1, Tab 6, are entirely appropriate. So it's Volume 1, Tab 6, at paragraphs 56 to 57, where my Lord Reed says that the
MS number, please.
MS is 1581, my Lord, 1581. And 56, the values underlying both the Convention and our own Constitution require the Convention rights should be protected primarily by a detailed body of domestic law. The Convention, a little bit at E, cannot therefore be treated as if it were Moses and the prophets. And going on, domestic law at 57 may, however, fail to reflect fully the requirements of the Convention. In that situation, it has always been open to Parliament to legislate. The courts have also been able to take account of those obligations in the development of the common law and in the interpretation of legislation. And then at the H, the importance of the Act is unquestionable. It does not, however, supersede the protection of human rights under the common law or statute, or create a discrete body of law based on the judgments of the European Court. Human rights continue to be protected by our domestic law, interpreted and developed in accordance with the Act when appropriate. And then a number of citations from particular situations where, as it were, the common law went further than the Convention. So we say, if the only reason for the limitation is a concept of territorial jurisdiction with limited extensions that dates back to the Convention in 1950, there is no reason why the common law should not progress beyond that. And the same in the case of Kennedy.
Before you go there, do you think there's anything in paragraph 61 and 62 which might be relevant?
Yes. Yes, the importance of continuing development of the common law in areas falling within the scope was emphasised by the Court of Guardian newspapers, yes. Yes.
The reference to sternum.
Yes.
And the ordinary approach to the relationship between domestic law and convention was described as being that the courts endeavour to apply and if need be develop
yes.
the common law.
My Lord, I'm very grateful, yes, because of course the international obligation here would be under the ICCPR, not just under the convention. But so I would respectfully submit that even if we did away with the convention tomorrow, the principle that we don't extradite to the death penalty would be a principle of common law. And we would be bound to apply it because of our signature of the second protocol of the ICCPR. The same goes, because it's the same underlying rationale, to any act that is directly instrumental in the causation of the death penalty.
In a very different field, one might think of a way the common law of privacy has developed extremely rapidly in order to reflect convention requirements.
No, well, my Lord, I do accept that, but after all, I'm not trying to just.
There's a point in your favour, I think.
But the prohibition on inhuman treatment is very much a homegrown notion.
Oh, yeah. Yeah.
I mean, where did the US get their Eighth Amendment from? The 1688 Bill of Rights. And now we're lagging behind all these things. But that's because we didn't need to, because we had statutes. But where there's a gap as here, there's no reason in our respectful submission why the principles should not be developed.
I was just giving it as an example of creativity in a situation where there was really precious little domestically to base the development on.
Yes, I see that. Yes, I see. So our fortiori in our...
Yes, exactly.
I'm
exactly.
very polite. Sorry, I missed the point.
He was trying to be constructive.
It may be my naturally antagonistic nature, I apologise.
Oh no, it's the natural antagonism that you expect of us.
No, my lady.
No, it's your suspicious nature, Mr. Fitzgerald.
The Greeks bearing gifts. But see if I can go on from there. But Kennedy, Volume 6, Tab 64. Again, the same basic underlying principle enunciated by Lord Mance. That's at page 4095 and 4098. So 4095, one has, paragraph 38, Lord Mance, page 4095, the development of common law discretions to meet convention requirements subject to control by judicial review has become a fruitful feature of United Kingdom jurisprudence. And then going on at paragraph 46, 4098, the convention, at B, the convention represents a threshold protection, and especially in view of the contribution which common law lawyers made to the convention's inception, they may be expected, at least generally, even if not always, to reflect and to find their homologue in the common or domestic statute law. And then again at C, in some areas the common law may go further than the convention, and in some contexts it may also be inspired by the convention rights and jurisprudence. And in time, of course, a synthesis may emerge. Well, it certainly would not be inconsistent with the whole arc of human history in this area to develop a principle that what goes for extradition and deportation goes also for other forms of instrumental causation of the death penalty. And so we rely on those principles. The HRA, as we say at 7.4, is not the sum of common law wisdom on the death penalty. And then finally, if I can very briefly deal with Sandiford and Zagorski to distinguish those cases, and could I just do it very shortly? Sandiford is at volume 1, tab 10, and it's at page 1653. And the court has it there. The question was whether to provide legal assistance in the form of this government paying for a lawyer for a British citizen in Indonesia facing the death penalty. And the finding of the House, the Supreme Court was that there was no challenge that could be brought to the policy of not providing legal support in a foreign jurisdiction for British citizens. Paragraph 8, one sees at page 1657 at H, the appeal to this court has proceeded as one of principle, directed to the legality of the policy. That's the policy of not providing paid assistance in a foreign jurisdiction, while, however, we are principally concerned with the legality of the decision made at that time, and the policy on which it was based, there is, as we understand it, no objection to us taking account of the new material. Then that goes on, if I can just take you to, it was held that it was not irrational to have such a policy and not irrational to apply it to the person in question, Mrs. Sandiford, and that's at 1673, para 72 to 73. The department seems to have responded at paragraph with appropriate urgency to the wholly unexpected death sentence. They are able to put the appellant in contact with an experienced local lawyer. Although it is argued that the small amount involved was a reason for making an exception to their policy, it could equally be a point in the other direction. So that the finding was that they hadn't fettered their discretion in a manner that was amenable to judicial review where the prerogative was concerned, that the policy itself wasn't open to challenge, and that the application of the policy to that particular individual wasn't open to challenge. And the general statement relied on by my learned friends and by the divisional court is at paragraph 23 at H. However, there is, and that's at 1661, however, there is no general convention principle that the United Kingdom should take steps within the jurisdiction to avoid exposing persons, even United Kingdom citizens, to injury to rights which they would have if the convention applied abroad. Now, one has to see that in its context. What was being relied on was a general convention principle, which we're not relying on. We're relying on a general common law principle. 2, there was no question there of the UK being instrumental in the causation of the death penalty. It was a question of whether we would have a discretionary policy to alleviate the dilemma of someone facing the death penalty by providing them with slightly better legal assistance. And it was held it was not irrational not to do so, because there were resource questions. That's a million miles from this situation, and we say that there is nothing in that dictum read in its context which could possibly support the proposition that there is therefore no duty not to be directly instrumental in the causation of the death penalty. There, the death penalty was a fact entirely separately caused by the Indonesian authorities' prosecution. And the question is, at the appellate level, should we pay for a lawyer? It's got nothing to do, in our respectful submission, with the situation that we're in here. And one cannot just, as it were, snatch out that sentence and say it's of general application to this situation.
Well, the difference is between active steps and passivity.
Yes.
I mean, here, there was no question of the United Kingdom taking active steps that would assist or be instrumental in the imposition of the death penalty.
That's the distinction we've sought to draw. And the same, in fact, applies to Zagorski, which is at is at page 1692, tab 12. There, if one looks at the head note, because it is quite complicated, there was the essential question was whether we should impose an export control on thiopental, sodium thiopental, which could have perfectly legitimate medicinal uses, but need not necessarily be resorted to by the US by acquiring it for a death penalty protocol. And the point about
Have you got a page reference?
I'm so sorry, my lady, it's 1692, my lady.
Thank you.
But really, that's one sees the facts, completely different facts. Do we stop the export of sodium thiopental, which may have perfectly legitimate medicinal uses, because it's possible that the UK source will be taken advantage of for providing that for the death penalty protocol? And at paragraph 28 in my Lord Lloyd Jones's judgment, the difficulties of causation are very clearly set out, where at 28, the reasons set out in the submission of the defendant can be summarised. That firstly, the fact that the goods could be for perfectly proper, legitimate medical purposes is set out 28.1a. And then the different forms of control are dealt with at 28.2 and 28.3. And then at 28.4, over the page 1701, a unilateral export control would be likely to be ineffective because it would not export exports from other parts of the European Union. So it's not only not causative, it's not a but-for situation at all. And that's the context again, which is crucial to my Lord's statement of principle at paragraph 80, where my Lord says at page 1714, I require no persuading that the common law can act to protect human rights quite independently of the Human Rights Act 1998. However, the extent of such protection and the relationship of the common law to the statutory rights conferred by the Human Rights Act require careful consideration. For example, beyond the established categories of case where a duty of care is imposed, there is no general common law duty. This seems to be with duty of care, that's to say negligence duty of care in mind, on Her Majesty's government to take positive steps to protect an individual's life from the actions of a third party. Again, my Lord, this is not about a duty not to be directly instrumental in the death penalty, but taking steps which might, and it's a very big might given paragraph 28, prevent the provision of sodium thiopental, which might be the sodium thiopental which is used by the US in the death penalty. So we say it really is a very, very different situation from ours. And my lady and my lords, we draw attention to the fact that my Lord Lloyd-Jones at paragraph 84 also makes the point that because the death penalty is involved, it would be a review of rationality issues on a heightened scrutiny, the anxious scrutiny from Bugdarkai and the case of Smith. So we respectfully, so my lady, those are our answers to the submissions of, to the reasoning of the Divisional Court. We say the Divisional Court, and it's at 7.9 at the top of F289, erred in its finding the present case should also be regarded as an omission to intervene. That analysis was achieved by separating the failure to give a death penalty assurance from the provision of evidence which will be relied on in a capital trial. But the court should look at the substance of the decision-maker's conduct rather than engage in an artificial separation of stages. Here it is accepted the Home Secretary is creating a risk of execution that would otherwise not arise. So we respectfully submit that the Divisional Court were wrong for all the reasons set out in that and for all the reasons set out in our reply, where we deal in more detail with that. The final point at paragraph 8 is the relevance of the specific US death penalty regime. May I just draw attention to the fact that they got it, with great respect, fundamentally wrong in saying that Pratt did not enunciate a common law principle. The whole ratio of Pratt was that if what was being done to the appellants in keeping them on death row for a prolonged period was permissible at common law, then it couldn't be challenged because of the savings clause in section 17.2 of the Jamaican Constitution. So the Privy Council had to, and did, as part of its ratio, ask itself, is execution after long delay contrary to the common law? And they answered, yes, it is. They answered that question in that way at 18E to 19D, page 6536, and that's volume 12, tab 128, at 20G to H, at 6537, at 28F to G at 6545, and at 29G at 6546 to 7. There can be no doubt that the ratio of Pratt and Morgan was to expose someone to a prolonged period on death row is contrary to the common law. And Lord Griffith said, why is it that we regard it as inhuman? It is because of our humanity. It's contrary to there's an instinctive revulsion based on our humanity. He was reasoning from a common law principle, and in Guerra and Baptiste, which we've got at 8.3, page 290, they again said that it was consonant, the prohibition on execution after a long delay was consonant with the tradition of the common law. Can I just give you, there's one more reference there, 414E is where they use the words consonant with the tradition of the common law to prohibit. So if you expose these suspects to the US death penalty regime, you expose them to a regime which has been found repeatedly by the Privy Council to violate the most fundamental common law norm and to be inhuman. And it cannot be right to exercise a prerogative power to inflict inhuman treatment that's contrary to the common law on these people. And my lady, it's firstly further aggravated by the points we make at 8.5 about suffering. But because of that, I needn't go into whether it's contrary to customary international law, but we say for the reasons set out at part 9 that it is. Suring says it's contrary to the European Convention. The Inter-American Convention regards it as at least part of what is inhuman. The UN Human Rights Committee has also said that after that long delay, coupled with other factors, and there's certainly other factors here, can constitute inhuman treatment. My lady, those are basically our submissions. Really, I think the rationality challenge flows from that. For all the reasons that I've put to the court, we would, in addition to the fact that it's unlawful, say it's irrational, and we would say that the test is, as my Lord Lloyd-Jones identified in Zagorski, a test of anxious scrutiny, and I think it was also in Sandiford said to be a test of anxious scrutiny, and that when one looks at it, the fundamental point is that if you're deriving your policy from the principle that we regard the death penalty as wrong in all circumstances everywhere, you can't say, but then we'll have some exceptions where we become complicit in it and where we directly contribute to it. It's just inconsistent. It's also inconsistent with the public statements. My lady, because we are on a tight time schedule, unless I can assist the court any further, can I cede to my learned friend?
It would appear that you can't.
Sorry.
I was just checking.
Thank you. Yes.
My lady, ground 2 might be thought a little more dry than ground 1, but we submit it's equally as dispositive. It's also a freestanding ground, so if the appellant fails to... So sorry. It's also, as I was saying, it's a freestanding ground, so even if the court is against us on ground 1, we still say it provides an answer in the appellant's favour. Now, without disavowing anything that we've put in writing, in light of the time constraints, may I just address 3 principal arguments? They are these. Firstly, the transfer was unlawful under the 2018 Act because it failed to comply with the mandatory statutory regime governing the transfer of data to third countries for law enforcement purposes.
Was or would be?
Was and would be. So in respect of 2 tranches it was, in respect of the proposed third tranche it would be. That's a regime that's provided by sections 73 to 76 of the Act, which I'll take you, and there's 2, and there's no dispute that it governed the transfer here. It provides a specific, mandatory and exhaustive regime which the respondent failed to have any regard to at all. Had he done so, for reasons that I will explain, he would have appreciated that the transfer of data without assurances, without full assurances, was prohibited. The second area in which I wish to focus is even if, contrary to everything I'm going to say about our primary case, the Act somehow permits the transfer of data for youth and death penalty proceedings even without any assurances at all, then the transfers were still unlawful. That's because, as I'll show you, there are at least 3 relevant provisions in the Act that apply a test of necessity. And the transfers were not necessary, nor would a further transfer be necessary, because less restrictive measures were available, including accepting the US's invitation for a direct use assurance, which appeared to have been still a lively possibility on the evidence. And the third aspect of illegality in which I intend to focus is procedural. The transfers were not lawful because they were made without regard to the substantive legal tests and the procedural protections provided by the Act. Indeed, remarkably, we say, they were made without any regard to the Act at all, despite the fact that it unquestionably governed the transfer of data to the United States. It had been introduced only weeks earlier with the respondent as its main sponsor, and despite the fact that the question of the transfer of data in this case was quite literally a life or death issue. And I'll submit that if retrospective shoehorning of the substantive legal tests or sanctioning of procedural breaches is permitted, then the essential protective purpose of the Act is materially undermined. My lady, I handed up, I hope it reached the court, a small file. Behind tab 1 is my intended roadmap of submissions. I'm going to address 8 topics in order to hopefully supply answers to those 3 or demonstrate where those 3 points are correct. I've also, mindful that this is a new Act and time was limited, put some tables behind tabs 2, 3 and 4 dealing with different aspects of the Act as a whole and part 3 in particular, and also given you a table whereby you can have cross-references to sections in the Act, to their place in the directive and the recitals, and also the Act's own explanatory note. And finally, behind tab 5, which I'll come to when I deal with necessity, is a chronology dealing with assurances on the evidence. Can I go straight into the first heading, which is how do you interpret the Act? And our first point is that the Act is a human rights instrument. It's a legislative response to how advances in technology, combined with globalization, have enabled vast amounts of data, often containing highly personal and sensitive information, to be collected, analysed, shared at a touch of a button without regard to territorial borders. And as with many advances in technology, these developments, of course, bring real benefits, not least in the realm of law enforcement, but also a real risk that they can act to infringe the fundamental rights of individuals, whether by malign intent or benign omission. As Lord Sumption put it in Cat, one of the more significant consequences of these societal developments has been to shift the balance between individual autonomy and public power decisively in favour of the latter. Part 3 of the Act is the response to the need to protect human rights in the context of processing of data for law enforcement purposes. It provides an exhaustive, substantive and procedural regime, including bespoke rules governing the transfer of data to third country recipients. The rights protected by Part 3 are not simply data rights or privacy rights, but they extend to the full range of fundamental rights that can be impacted when data is processed. That's a point that was made in respect of the predecessor Act by Mr. Justice Green, as he then was, in the Zor-Lin case. Can I simply give the court references? Authorities, Volume 1, Tab 13, MS 1716, paragraphs 58, 60 and 69. Now, I make this my first point because the fact that it's a human rights instrument has a material bearing on how we interpret it. It means in our submission it should be given a teleological interpretation consistent with the aim of protecting rights, and that restrictions on fundamental rights should be narrowly interpreted. And it also gives emphasis to the importance of procedural safeguards. And in respect to fundamental rights, it's also important to stress at the outset that this case doesn't simply concern the fundamental rights of Coty and El-Sheikh, but it also, this case, engages the fundamental rights of the hundreds of people who gave witness statements as part of the Metropolitan Police investigation. For your note, you'll see the letter from the Home Secretary to Mr. Sessions at MS 520, where he refers to an investigation that took over 4 years, involved engagement with over 14 countries, and took over 600 witness statements. This means that there are hundreds of data subjects whose data protection rights are likely to have been breached in this case. Reasonable to assume that most will not be suspected of terrorism. Most, no doubt, were seeking to assist the police in their inquiries, and some of whom may well be appalled to learn that their data was being transferred for use in death penalty proceedings. Can I move to point 2 in the roadmap? About the implementation of the law enforcement directive and why it matters not whether the opt-out while the opt-out doesn't bear upon the interpretation of the Act. That's an important point, we say, particularly if you are against us on ground one, because the answer to this question is capable of determining the contents of the fundamental rights that are protected in the Act. Can I identify 5 points? We say they should be uncontroversial, but they lead to only one conclusion consistent with our bullet point. Firstly, Section 1, subsection 4 of the Act provides in unqualified terms that the very purpose of Part 3 is to implement the directive. That's MS 1251. Secondly, a considerable amount of law enforcement data processing with our EU partners is in scope. And in respect of these activities, the United Kingdom was obliged to transpose the directive. Thirdly, flowing from this, there can be no dispute that when considering in-scope data processing, the Act must be interpreted and applied consistently with the directive. That means, again, obviously we would say, interpreting the directive itself consistently with the body of EU law, its fundamental principles and sources, including, of course, the Charter. Fourthly, although under no obligation whatsoever to do so, Parliament chose to transpose the Law Enforcement Directive to cover, without qualification or exception, all data processing for law enforcement purposes, irrespective of whether it was in scope or out of scope. As the explanatory note details, for your note, paragraph 57 at MS 1443, the only changes to the text of the directive in the Act was where elaboration was required to reflect UK drafting style, clarify the legal effect of a provision, or take advantage of some flexibility afforded by the directive. Fifthly, this method of implementation was for a reason. It was because Parliament decided to create a single regime which would apply in a uniform way to all law enforcement data processing, irrespective of whether the circumstances of a particular case fell within or without the scope of EU law. Can I just give you references for that in the explanatory note, paragraphs 40 and 56 at MS 1440 and 1443, and also for your note, see our submissions and those of the Information Commissioner as to why the unitary scheme accords both with the need for regulatory alignment, both pre- and post-Brexit, and also with the practical realities of cross-border law enforcement. That's in our case at paragraphs 11.6 to 11.8 at MS 300, at the ICO's paragraphs 12 to 17 at 399. Now we say the simple logic of these 5 points is that if you have to apply the directive in EU law to in-scope processing under Part 3, then the unitary scheme demands you apply precisely the same rubric to out-of-scope processing. If you start applying bespoke domestic definitions and interpretations to processing covered by the opt-out, you create the very bifurcated regime that the method of implementation sought to avoid. Thus, we say it's not the appellant who seeks an interpretation contrary to the intent of Parliament. The respondents argue for some form of differential interpretational approaches, depending on whether the transfer is in scope or out of scope. And in respect of the latter, they say that the directive must be given attenuated relevance. But we say, insofar as it means that a transfer could be lawful if out of scope, but unlawful if in scope, it leads to bifurcation and is contrary to the will of Parliament. So the simple point we make is that in all cases under Part 3, it needs to be read consistently with the directive for the purposes of assessing whether the transfers in this case were ultra vires or intra vires of the Act. I move to my third point, my lady. that the fundamental rights protected by the directive, and thus the Act, are enjoyed by the data subjects irrespective of their place of relevance. And the primary sources for those are EU law, including obviously the Charter and the European Convention, and to which we add, of course, all of which are entirely consistent with our own domestic law. Could I first show you the recitals, some of the recitals to the directive, because they make plain that the requirement to protect the fundamental rights of data subjects arises irrespective of their place of relevance. And we'll find the directive in Authorities 2, tab 19, starting at MS 1953. And at recital 2, principles of and the rules on the protection of natural persons with regards to the processing of their personal data should, whatever their nationality or residence, respect their fundamental rights and freedoms. Over to 1955 and recital 17, the protection afforded by this directive should apply to natural persons, whatever their nationality or place of residence, in relation to the processing of their personal data. The question is then, what does the directive mean when it refers to fundamental rights? What's their content? And we say that the apex source for defining what in an EU directive would be considered as a fundamental right is obviously the Charter on Fundamental Rights. And by Article 52(3) of the Charter, which makes plain the rights it guarantees corresponds to those in the European Convention, we also say the European Convention. And indeed, the recitals to the directive, as we set out in our written case, are replete with references to the Charter and the European Convention on Human Rights. And indeed, it makes plain in terms. Can I just show you recital 46 at MS 1960? Any restriction on the rights of the data subject must comply with the Charter and the ECHR, as interpreted in the case law of the Court of Justice and the European Court. Now, this isn't creating, for a moment, any directly enforceable rights under the Charter or the European Convention of Human Rights to those who have none. The Charter and the European Convention merely provide the source for understanding and interpreting what is meant by fundamental rights in the directive and thus the Act. And those rights arise irrespective of a data subject. In contrast to the European Convention of Human Rights and its obvious territorial boundaries under Article 1, the directive has no such jurisdictional limits. To the contrary, it expressly extends its protections to those resident anywhere. So accordingly, we say the obligation to protect fundamental rights when processing data under the Act is an obligation to protect those rights which correspond to fundamental rights in the Charter and the European Convention. They are not dependent upon the vagaries of human rights protections in the country of residence of either the data recipient or the data subject. Now, it might not matter in this case, and obviously our primary submission is it does not matter, because the primary rights we rely on under the Charter are all reflected in our own domestic law, not least the right to life and the prohibition on the death sentence, and the right to not to be exposed to inhumane or degrading punishment. I set out those 3 points by way of background because they're important when we come to my fourth point, which looks at the particular gateway provisions. So this is essentially the lex specialis governing the transfer of data to overseas recipients for the purposes of law enforcement. So this is my fourth point. And those working on paper might want to have both the Act in Authorities 1 tab 2 and the Directive 219 to hand. Can I take you first to the Act and to section 73 at MS 1330.
Yes.
At 1330, my lord. So see, this is Chapter 5 of Part 3 under the heading Transfer of Personal Data to Third Countries, and it sets out general principles. You'll see the mandatory terms of Section 73.1. A controller may not transfer personal data to a third country unless the three conditions set out in Section 2 to 4 are met. And you can see that under subsection 2, condition 1 is that the transfer is necessary, and I'm going to come back to necessity later. But condition 2 is this, that the transfer is either based on an adequate decision under section 74, if not based on an adequate decision, is based upon there being appropriate safeguards, see section 75, and if not based on an adequate decision or there being appropriate safeguards, is based on special circumstances. Now, the court has our submissions in writing and those of the Information Commissioner that the gateways under condition 2 don't give the data controller free rein to select which one he or she might want to choose, but rather there is a hierarchy. And just for your note, the Information Commissioner makes that point at paragraphs 58, 61 and 64 of her written submissions from MS 409. And we make that point with explanation in paragraph 15.2 at 315. Because as you'll see, it's a descending scale of procedural rigour. Section 74 deals with adequacy decisions. Now, that's a decision that's given by the Commission, and there's no decision here, but it is instructive to look at the recital that relates to the directive and in turn section 74, because you'll see the stress that is given to the protection of human rights in the recital, and the need for the Commission, when considering whether or not to make a decision, to have regard to that. So we are back in volume 2 at tab 19, MS 1963. Could I ask you just to mark all of paragraph 66 to 70? But could I just take you for now to 67, which says this: in line with the fundamental values on which the Union is founded, in particular the protection of human rights, the Commission should, in its assessment of the third country or territory or specified sector, take into account how a particular third country respects the rule of law, access to justice, as well as international human rights norms and standards, and its general sectorial law, including legislation concerning public security, defence and national security, as well as public order and the criminal law. And then if you would just go down a few lines, the third country should offer guarantees ensuring an adequate level of protection, essentially equivalent to that ensured within the Union. So we say, in short, that it is inconceivable that the Commission would grant an adequacy decision for law enforcement purposes to enable, to sanction the transfer of data, perhaps without a blanket a death penalty, full death penalty assurance. Inconceivable it would do it where that country would use or could use that data for death penalty proceedings. And without a full assurance, a legal order that permitted the death sentence would come nowhere close to offering the essentially equivalent human rights protections as to those of the EU. It permits the data to be used to facilitate a form of punishment that is anathema to the values of the European Union. In the absence of a decision under section 74, we turn then next to section 75. You'll find that at MS 1338. Now, that deals with transfers on the basis of appropriate safeguards. So a transfer of personal, under subsection 1, a transfer of personal data to a third country is based on there being appropriate safeguards where either a legal instrument containing appropriate safeguards of the protection of personal data binds the intended recipient, or the controller, having assessed all the circumstances surrounding transfers of that type of personal data to the country, concludes that appropriate safeguards exist, and obviously I underline exist, to protect the data. Again, the recital is highly informative. This is recital 71, which the court will find on MS 1964. Transfers not based on such an adequate decision should be allowed only where appropriate safeguards have been provided in a legally binding instrument, ensures protection of personal data, or where controller assessed all the circumstances around the data and on the basis of that assessment considers appropriate safeguards exist, and talks about legally binding documents. And then if you could just go to the bottom of that recital, please, 4 lines up. In addition, the controller should take into account that the personal data will not be used to request, hand down, or execute a death penalty or any form of cruel and inhumane treatment. While those conditions could be considered to be appropriate safeguards allowing the transfer of data, the controller should be able to require additional safeguards. Now, my learned friends argue that the reference to the death penalty in recital 71 assists him, because he says it reflects a discretion to transfer data, even if it's going to be used to facilitate the death penalty. And we say, firstly, that is a reading that is impossible to reconcile with the whole purpose of the Act, which is to prevent data processing from infringing rights that the EU considers to be fundamental. A fortiori, as I'm going to go on to develop, when they are absolute rights. And we say the only proper reading of that recital, which entirely supports our case, is that it assumes as a minimum that appropriate safeguards could only exist in a country where data will not be used to facilitate the death sentence. My learned friend's interpretation could only work if the wording was that controllers should take into account whether or not the data was going to be used. Here it assumes, entirely consistent with EU values, that it will not be, that a decision can only be made in a country that will not use it. You would test it this way. On my learned friend's reading of the recital, it permits a controller to take into account whether or not a country would use that information for the purposes of the infliction of cruel and unhuman treatment. On my learned friend's reading, so long as that's taken into account by the data controller, it can nevertheless proceed. It's entirely contrary to the purpose of the directive. And of course, here the stark facts are, looking at the wording of the section, is that the transfer was without any safeguards whatsoever, despite the explicit acknowledgement of the potential human rights impact of the transfer. So it was impossible for the respondent to satisfy the requirements of section 75(1)(b) and reach a conclusion that appropriate safeguards existed to protect the data when none did. Had that adequate safeguards analysis been conducted, the only answer the Secretary of State could have reached was that it was impermissible to transfer that data without a full death penalty assurance. Now, if you don't carry out, or I beg your pardon, if you are unable to carry out an appropriate safeguards assessment, then Section 76 permits transfer under a special circumstances gateway. We can see that at MS 1340. So a transfer of personal data to a third country is based on special circumstances where the transfer is necessary. Again, I underline necessary. It's yet another necessity test. And then D, an individual case for a law enforcement purpose. And then whilst we're there, because I'm going to come to it in a moment, subsection 2, but subsection 1D doesn't apply if the controller determines that the fundamental rights and freedoms of the data subject override the public interest in the transfer. The relevant recital is recital 72. Which stresses the limited exception and the need to construe it within the bounds of strict necessity. Now, this is the ground on which my learned friend says permits that which would be unpermissible under the previous sections. Now, it is right that the descending hierarchy reflects some flexibility in respect of process, to take account of the need to transfer, on occasion, data quickly because, for example, of an unforeseen practical imperative. But in our submission, it would be entirely contrary to the purpose of the Act to read it as watering down the requirement to ensure that the fundamental rights of data subjects are not breached. So, of course, there's a greater risk under this section that rights will be breached, because if you don't carry out a full assessment, there may be unforeseen human rights consequences of the transfer, because it's not as rigorous as assessment. That's often the nature of decisions that have to be taken quickly by necessity. But that's decidedly not this case. In this case, there wasn't an unforeseen risk. It was a clear and acknowledged risk, and it was an acknowledged risk of a breach of an absolute fundamental right. And that cannot be sanctioned under Section 75. I beg your pardon, under Section 76. You can't, under that section, sweep under the carpet transfers of human rights transfers of data that you acknowledge are going to harm human rights that would be impermissible under the other gateways. The only protections that are lessened under this third gateway are of procedural protections, because you don't carry out the same thorough assessment. Any other interpretation would be contrary to the purposes of the Act. And that is in fact reinforced, we say, by subsection 2 of 76 at 1340. My learned friend relies on the wording in section 76.2, calling for a balancing act. But in fact, we say that serves to emphasize the point I'm making. It can only be read as overriding qualified fundamental rights in an individual case. That's a type of balancing exercise that finds an obvious analogue in human rights instruments, not least the ECHR. And indeed, just to remind the court, you only get to section 76 if you pass through other tests, not least the first data protection principle, that there's a lawful basis for the transfer in the first place. So this is simply a mechanism that addresses qualified rights, because we submit it would be wholly contrary to the purposes of the directive and the Act for a transfer to be sanctioned that knowingly gave rise to a real risk of breach of an absolute right. A fortiori through section 76, where the procedural protections are lessened. All the more reason to be vigilant that what is going through section 76 is incapable of breaching fundamental rights. A fortiori, when those rights are incapable of qualification, they are incapable under the European legal order of being qualified by anything. And that is why we submit that in this case, which engages the absolute fundamental rights not to be condemned to the death penalty, nor to be subjected to inhuman or degrading treatment, rights at the core and ingrained into the fabric of the Union, it's inconceivable that the transfer of data in these circumstances could be permitted under the Act.
It could have been made much more explicitly clear, couldn't it?
Well,
I mean, it's fairly loose use of language if your central submission is correct.
well, my Lord, that is probably a criticism that can be applied not just to this directive or implementing legislation.
Well, I
But
think it's really the legislation that I'm focusing on when I make that observation.
Yes.
It may be that's unduly harsh observation, but it certainly seems to require a fair amount of, if not assumption, certainly analysis to get to the point that you wish to take us.
But that's why, my Lord, I started by stressing two things. Firstly, the human rights nature of the Act. But secondly, and importantly, the relationship it bears with the directive that it implements. And that's why I've taken you to the recital. That's why in our printed case we emphasise that the purpose of the directive is to protect fundamental human rights when information is transferred, which is why we'd say it is just impossible to reconcile sanctioning under this regime of transfer of information for death penalty purposes.
But on your submission, there's a calibrated level of protection, and the level of protection for qualified rights under the Convention is not as great as for unqualified rights.
That's right. That's why I say there is an analogue with, for at least the European Convention of Human Rights. So what the directive and the Act is not doing is saying that for all purposes, you cannot transfer data that would impact upon any fundamental right. I mean, that would be unworkable. I mean, not least under the Charter, the right to data, the privacy of data. What the directive does and what the Act seeks to do is to provide a framework for ensuring the fair processing of that data, so that in respect of a qualified right, it can only be transferred once proper weight and consideration has been given as to whether it is necessary and proportionate. Just because of the nature of absolute fundamental rights within our legal system, just as you couldn't have a balancing act under the European Convention of Human Rights in respect of, say, the right to life or the right to be free from inhumane treatment, nor can you, we say, under the terms of this Act, which transposes the directive and has the Charter as its source in respect of definition of fundamental rights. So, my Lord, I have no doubt there could have been a more elegant way of drafting these parts of the Act.
I'm also concerned about elegance. Explicitness, I think, is the answer. But in any event, your central point is there are certain unqualified rights in the Convention, and it's inconceivable that legislation should allow them to be assessed as a need of protection on some form of balancing act.
Yes, well, we'll see recital, for example, I took you to recital 46, which says that rights can only be restricted under the directive consistently with the Charter and the European Convention. So you can't obviously restrict under the Charter of a European Convention the right to life. So if my Lord's asking me to distill it down into the kind of the kind of minimum core proposition, it's that. My Lord, my Lady, the next topic under 5 is the prohibition on the facilitation of the death penalty is consistent with the values that underpin the EU legal order. And you would have seen in our printed case, we set out a wealth of materials to support that proposition. Can I just simply say this, that in respect of the directive, the court doesn't actually need to decide whether EU law has a general freestanding principle of non-facilitation of the death penalty overseas. And that's because we say that the directive makes clear, in the particular context of law enforcement, that any transfer of data for the purposes of the death penalty proceedings, absence of full assurance, is prohibited. So whether or not there's a wider, which we say there is, but whether or not there's a wider, broader principle of non-facilitation is an interesting point, but it doesn't bear upon the operation of the directive or the Act.
Well, you've reached your deadline for today. No doubt you'll continue tomorrow morning. The court will sit at 10 o'clock.